I installed the heated sidewalk system on a freezing Tuesday in November, watching the contractor finish the final connections with a sense of genuine pride. The radiant heating coils ran beneath the concrete pathway from my driveway to my front door, designed to automatically activate when temperatures dropped below 32 degrees and moisture was detected. I had spent nearly $8,000 on this setup at my house in Maple Grove, Minnesota, and after 3 winters of watching my elderly mother nearly break her hip on my icy walkway, I considered it money well spent. The system worked flawlessly for exactly 9 days before I received the first letter from the Homeowners Association. I stood in my kitchen on a Wednesday morning, still wearing my bathrobe, staring at the pristine white envelope with the return address labeled Maple Grove Estates HOA. My coffee grew cold in my hand as I read the typed complaint. According to the letter, signed by one Patricia Whitmore, HOA president, my heated sidewalk system constituted an unauthorized exterior modification that violated Section 7.3 of the Community Covenants. I was being ordered to remove it within 30 days or face daily fines of $100. I read the letter 3 times, certain I had misunderstood something. The system was entirely beneath the surface. You could not see it unless someone pointed out that my sidewalk remained mysteriously clear of snow and ice while everyone else scraped and salted like medieval peasants. I had checked the covenants before installation. Section 7.3 dealt with visible exterior changes like paint colors, landscaping alterations, and architectural additions. Nothing about underground heating systems. I called the HOA office that afternoon and reached a woman named Deborah who answered with the enthusiasm of someone describing a root canal. Maple Grove Estates, HOA. This is Deborah speaking. Hi, my name is Quinton Lancaster. I received a letter about my heated sidewalk, and I think there has been some mistake. The system is completely underground and does not change the appearance of anything. Hold, please. Elevator music assaulted my ears for 4 minutes before Deborah returned. Mr. Lancaster, I have your file here. The violation stands. Patricia Whitmore personally inspected your property and documented the unauthorized modification. But what modification? You cannot even see it. The absence of snow and ice on your walkway, while neighboring properties retain normal winter conditions, constitutes a visible alteration to the community aesthetic. I actually pulled the phone away from my ear and stared at it, wondering if I had somehow entered an alternate dimension. You are saying that having a clear sidewalk is a violation. Having a sidewalk that appears different from the community standard, yes. Section 7.3 is very clear about maintaining uniformity. That section says nothing about heated sidewalks. It says exterior modifications require approval. You did not seek approval because it is not visible. The covenant specifically addresses visible changes. Deborah sighed with the patience of a kindergarten teacher addressing a particularly slow child. Mr. Lancaster, the system causes a visible effect, therefore it is visible. You have 29 days remaining to comply. Good day. She hung up before I could respond. I spent that evening reading through every page of the community covenants, cross-referencing with the architectural guidelines and the supplementary rules addendum. Nowhere did I find anything that could reasonably be interpreted to ban an underground heating system. The more I read, the more convinced I became that Patricia Whitmore had simply decided she did not like my heated sidewalk and had invented a justification after the fact. The next morning, I drove to the HOA office, a small suite in a strip mall near the community entrance. Patricia Whitmore sat behind a large desk that seemed designed to intimidate visitors. every surface covered in neatly organized files and labeled folders. She was probably 55, with short blonde hair styled in that aggressive soccer mom cut that somehow always signaled trouble. She wore a cream-colored blazer and a pearl necklace that looked expensive enough to fund a small country. "Mr. Lancaster," she said, not rising or offering her hand. "I assume you are here about your violation. I am here about your misinterpretation of the covenants. My heated sidewalk does not violate anything. That is not for you to decide. The HOA board reviewed your case and unanimously agreed that your modification requires removal." "Show me where in the covenants it says that." Patricia opened a thick binder and pointed to section 7.3. I had already memorized it. "That addresses visible exterior changes. My heating system is invisible. The effect is visible. Your sidewalk remains clear while others accumulate snow and ice. This creates a non-uniform appearance that detracts from community standards." I leaned forward, keeping my voice level. "So you are telling me that keeping my sidewalk safe and clear is a violation because it makes other people's icy death traps look bad by comparison? I am telling you that you made an unauthorized modification. The solution is simple. Remove the system or pay the fines. Your choice." This is insane. I spent $8,000 on a safety feature that helps everyone who walks on my property. My 78-year-old mother visits twice a week. This system literally prevents injuries. Patricia's expression did not change. "Then you should have sought approval before installation. Perhaps the board would have granted it. Would you have? No, we have standards to maintain." I left the office before I said something I would regret, my hands shaking with frustration. Over the next week, I researched Minnesota HOA law, consulted with 2 different attorneys, and prepared a formal written appeal to the board. The attorneys both told me the same thing. The covenant language was ambiguous enough that the HOA could potentially enforce their interpretation, but I had a reasonable case for challenging it. Fighting would cost thousands in legal fees with no guarantee of success. Removing the system would mean eating the $8,000 installation cost and returning to the ice skating rink that had nearly killed my mother. I submitted my appeal with detailed photographs, a copy of the installation plans, citations from Minnesota HOA statutes, and a passionate argument about the safety benefits. The board meeting was scheduled for a Thursday evening in mid-December. I arrived at the community center 15 minutes early. A dozen other homeowners sat in folding chairs arranged before a long table where 5 board members would preside. Patricia sat in the center position, flanked by 2 middle-aged men who looked vaguely uncomfortable and 2 women who appeared to be Patricia's clones, right down to the aggressive haircuts and pearl necklaces. My case was third on the agenda. The first 2 involved minor disputes about Christmas decorations. Patricia ruled against both homeowners with the efficiency of a guillotine operator, citing various covenant violations and imposing fines. Neither homeowner bothered arguing. They simply nodded and left, defeated before they started. When Patricia called my name, I approached the table with my documentation. "Mr. Lancaster, you have submitted an appeal regarding the heated sidewalk violation. The board has reviewed your materials. You have anything to add?" "Yes." "I want to emphasize that this system poses no aesthetic impact to the community. It is completely underground. The only visible effect is a safer walkway, which should be encouraged, not penalized." I have included citations from Minnesota statute showing that safety modifications are generally protected, even in HOA communities. One of the men, whose nameplate read Donald Grayson, cleared his throat. "Mr. Lancaster, I actually think you might have a point here. The covenants do not specifically address underground systems, and the safety argument is compelling. Patricia's head snapped toward him like a snake striking. Donald, we discussed this. The covenant language is clear. Any modification affecting exterior appearance requires approval. But it does not really affect appearance, Donald said, his voice uncertain. It just keeps his sidewalk clear. Which creates a visible difference, Patricia shot back. That is an effect, therefore it is visible. The other board members nodded in agreement. Donald looked down at his papers and said nothing more. Mr. Lancaster, Patricia continued, your appeal is denied. You have 22 days remaining to remove the system or begin accruing fines. This matter is closed. This is not closed, I said, my voice rising despite my best efforts. You are interpreting the covenants in bad faith to target a legitimate safety improvement. I will fight this. You may certainly try, Patricia said, her tone dripping with condescension. Legal action will be expensive and time-consuming. Much easier to simply comply. Next case, please. I left the meeting seething, barely hearing the next homeowner's complaint about a barking dog. Outside, Donald Grayson caught up with me in the parking lot. Mr. Lancaster, wait. I just want to say off the record that I think Patricia is being unreasonable, but she controls the board. The other members follow her lead on everything. So what am I supposed to do? Donald glanced back at the community center, then lowered his voice. Document everything. Every interaction, every letter, every fine. If you do end up in court, you will want a clear record of how unreasonable they have been. And between you and me, Patricia hates when homeowners make improvements she did not think of first. This is personal for her. He walked away before I could respond, leaving me standing in the cold parking lot with a growing sense that I was in for a much longer fight than I had anticipated. The fine started on day 31. $100 per day, added to my quarterly HOA dues statement. I refused to pay them. I also refused to remove the heated sidewalk system. Instead, I installed a security camera pointed at my front walkway, documenting the steady stream of delivery drivers, mail carriers, and neighbors who used my clear, safe sidewalk instead of risking the icy paths elsewhere in the neighborhood. Patricia escalated quickly. By mid-January, I had received 3 more letters, each more threatening than the last. The daily fines continued accumulating. By early February, I owed the HOA over $4,000 in penalties. They placed a lien on my property. That was when things got interesting. Minnesota experienced a particularly brutal cold snap in February, with temperatures plunging below zero and an ice storm coating everything in a 2-inch crystalline shell. My heated sidewalk activated automatically, keeping my walkway completely clear. The rest of the neighborhood looked like a skating rink. I watched from my window as neighbors crept carefully to their cars, feet sliding, arms windmilling for balance. Patricia Whitmore visited my property on a Friday morning, presumably to document my continued violation. I watched through my security camera as her BMW pulled up to the curb. She climbed out wearing designer boots with absolutely no traction, carrying a tablet for photographs. She started walking up my neighbor's icy driveway to get a better angle of my house. Her feet went out from under her so fast it looked like a cartoon. One moment she was upright, the next she was flat on her back, her tablet skittering across the ice. She lay there for a moment, stunned, before slowly struggling to her feet. She limped back to her car without taking any photographs. I felt no sympathy whatsoever. 2 days later, on Sunday morning, I was drinking coffee and watching the news when my doorbell rang. I opened it to find Patricia standing on my heated sidewalk, notably not on my neighbor's icy driveway, holding yet another letter. Mr. Lancaster, I am hand-delivering this notice of acceleration. Your fines now total $4,300. If not paid within 10 days, the HOA will pursue foreclosure proceedings. I looked down at her feet, planted firmly on my clear, dry, heated sidewalk. Then I looked at her face. You are standing on my heated sidewalk right now, the one you claim is such a terrible violation. I am delivering legal notice, which is my responsibility as HOA president. You could have left it in the mailbox. Instead, you walked up my heated sidewalk because it is the only safe path to my door in these conditions. Do you see the irony here? Patricia's jaw tightened. 10 days, Mr. Lancaster. I suggest you take this seriously. She turned and walked back down my heated sidewalk, carefully avoiding the icy driveway where she had fallen 2 days earlier. I closed the door and immediately called one of the attorneys I had consulted before. His name was Marcus Webb, and he specialized in HOA disputes. He listened to my story, reviewed my documentation, and agreed to take my case. Here is the thing, Marcus said during our first official meeting. HOAs have broad authority, but they cannot act arbitrarily or in bad faith. The fact that Patricia is using your heated sidewalk while simultaneously claiming it is a violation shows bad faith. The fact that you have video evidence of her fall and her subsequent use of your safe walkway is gold. We can work with this. What are my options? We file a complaint in district court challenging the fines and the lien. We argue that the HOA is misinterpreting the covenants and acting unreasonably. We also file a counterclaim for the cost of removing and reinstalling the system if you lose, plus emotional distress. But honestly, I think we can get this thrown out before trial if we present the evidence properly. How much will this cost? My retainer is $3,000. If it goes to trial, probably another $5,000 to $10,000 depending on how long it takes. But if we win, we can try to recover attorney fees from the HOA. I signed the retainer agreement that afternoon. Marcus filed the complaint the following week. The HOA responded by immediately suspending the foreclosure proceedings but maintaining the fines and the lien. Patricia sent me a letter stating that my frivolous lawsuit would fail and that I was wasting everyone's time and money. The court scheduled a preliminary hearing for mid-March. In the meantime, winter continued its assault on Maple Grove. My security camera captured a steady parade of incidents in the neighborhood. A FedEx driver slipped on someone's front steps and dropped a package, which slid into a snowbank. The mail carrier fell twice in 1 week on icy sidewalks, both times pulling himself up using mailboxes. A teenager wiped out on his driveway and hobbled inside, clearly injured. And then, on a particularly icy Tuesday in late February, Patricia Whitmore fell again. This time it was not on my neighbor's property. She was walking to her own car, parked on the street near my house while she conducted yet another inspection tour of properties to find violations. My security camera caught the whole thing. She stepped off the curb, her foot hit a patch of black ice, and she went down hard. She lay on the frozen pavement for almost 30 seconds before managing to get up, clearly in pain. She limped to her car and drove away. I immediately downloaded the footage and sent it to Marcus. "This is perfect," he said when he called me back. "This shows a pattern. She keeps falling on ice while penalizing you for eliminating ice. It goes directly to the reasonableness of her actions. Can I use this in court?" "Absolutely." The preliminary hearing arrived on a cold Thursday morning. I met Marcus at the county courthouse in downtown Minneapolis. We sat at the plaintiff's table while Patricia and the HOA's attorney, a stern-looking woman named Jennifer Paulson, sat at the defendant's table. The judge was a woman in her 60s named Margaret Flores. She reviewed the filings with a skeptical expression that seemed directed equally at both parties. "Mr. Webb, you are arguing that the HOA has misinterpreted its own covenants and is acting in bad faith. That is a serious allegation." "Yes, Your Honor. And we have substantial evidence to support it. The covenant in question addresses visible exterior modifications. Mr. Lancaster's heating system is completely underground and invisible. The only visible effect is the absence of ice and snow, which is a safety benefit, not an aesthetic modification. Furthermore, the HOA president herself has repeatedly used Mr. Lancaster's heated sidewalk, including immediately after falling on ice elsewhere, which demonstrates that she recognizes its safety value while simultaneously penalizing him for providing it. Judge Flores turned to Jennifer Paulson. "Counselor, how does the HOA respond?" "Your Honor, the covenants give the HOA broad discretion to interpret and enforce community standards. The board determined that Mr. Lancaster's heating system creates a visible effect that differs from the community norm. That is within their authority. Whether or not individual board members use the sidewalk is irrelevant to the covenant violation." "It goes to bad faith," Marcus interjected. "If the HOA president believes the heated sidewalk is such a serious violation, why does she use it?" "Because it is there," Jennifer replied. "Using a sidewalk does not constitute approval of an unauthorized modification." Judge Flores held up her hand. "I have heard enough for now. Mr. Webb, I want to see your evidence of bad faith. I will give you 20 minutes to present it. If it is compelling, we will schedule a full hearing. If not, I am inclined to defer to the HOA's interpretation of its own covenants." Marcus stood and connected his laptop to the courtroom display. For the next 20 minutes, he showed the judge everything I had documented, the security footage of Patricia falling on ice, the footage of her subsequently using my heated sidewalk to deliver notices, the statistics I had compiled showing multiple injuries on icy sidewalks in the neighborhood, the photographs of my elderly mother safely navigating my clear walkway, the emails I had sent to the HOA board about safety concerns, all ignored, the Minnesota statutes protecting reasonable safety modifications. Judge Flores watched intently, asking occasional questions. Patricia's face grew redder with each piece of evidence. When Marcus finished, the judge sat back in her chair. "Counselor Paulson, I will be honest. This does not look good for your client. The evidence suggests that the HOA is enforcing a questionable interpretation of its covenants in a way that penalizes a legitimate safety improvement, while the HOA president herself benefits from that improvement. That strikes me as arbitrary and unreasonable. Your Honor, the HOA has the right to maintain community standards, not in a way that is arbitrary, capricious, or discriminatory. I am scheduling a full hearing for 6 weeks from now. In the meantime, the HOA will suspend all fines and may not pursue foreclosure. Mr. Lancaster may keep his heated sidewalk operational pending resolution. We will determine the covenant interpretation at the full hearing." Patricia stood up abruptly. "Your Honor, this is outrageous. We have every right to enforce our covenants." "Sit down, Mrs. Whitmore," Judge Flores said coldly. "You will have your opportunity to present your case at the full hearing. Until then, my order stands." We left the courthouse with what Marcus called a solid preliminary victory. The fines were suspended. The lien remained but could not be acted upon. Most importantly, I could keep using my heated sidewalk without accruing additional penalties. Patricia was not done fighting, though. Not by a long shot. Over the next 6 weeks, She became obsessed with finding other violations on my property. I received letters about my mailbox being half an inch too far from the curb, about a microscopic paint chip on my garage door, about my trash cans being visible from the street for 10 minutes longer than allowed on collection day. Each letter was meticulously documented, photographed, and filed with the HOA. I forwarded every single one to Marcus, who added them to our evidence file under harassment and retaliation. The full hearing was scheduled for late April. Minnesota had finally thawed, and my heated sidewalk system sat dormant, waiting for next winter. But the principle remained. I had installed a safety feature that I had every right to have, and the HOA had acted unreasonably in trying to ban it. Marcus spent weeks preparing our case. He deposed Patricia, Donald Grayson, and the other board members. He subpoenaed HOA records showing selective enforcement of covenant provisions, finding multiple instances where other homeowners had made modifications without approval, but had not been fined. He hired an expert witness, a community planning consultant, who testified that heated sidewalks were becoming increasingly common and represented a reasonable safety improvement that HOAs should encourage, not penalize. The hearing took place on a Tuesday morning in late April. The courtroom was larger this time, with more people in attendance. Apparently, word had spread through the neighborhood about the case. Several of my neighbors showed up to watch, along with local media interested in the unusual dispute. Judge Flores called the hearing to order and gave Marcus the floor first. For 3 hours, Marcus methodically presented our case. He showed the covenant language and explained why it did not reasonably encompass underground heating systems. He presented the safety evidence, including statistics on slip and fall injuries in Minnesota winters. He called me to the stand to testify about my mother's near injury and my decision to install the system. He showed the security footage of Patricia falling and then using my heated sidewalk. Then he dropped his bombshell. Your Honor, during discovery, we uncovered evidence that Mrs. Whitmore has her own heated driveway at her residence, installed approximately 8 years ago. The courtroom erupted in whispers. Patricia's face went pale. The HOA covenants have not changed in that time period. Yet Mrs. Whitmore has never been cited for a violation, never asked to remove her system, and never disclosed this fact when penalizing Mr. Lancaster for the same type of installation. This is not just bad faith. This is discriminatory enforcement and selective application of the rules based on personal animus. Jennifer Paulson jumped to her feet. Your Honor, Mrs. Whitmore's driveway heating system is different. It was professionally installed, and so was Mr. Lancaster's, Marcus interrupted. By the same company, as it turns out. We have the installation records for both properties. Identical systems. Identical permits from the city. The only difference is that Mrs. Whitmore approved her own installation as HOA president while denying Mr. Lancaster's after the fact. Judge Flores turned to Patricia. Mrs. Whitmore, is this true? Do you have a heated driveway? Patricia stood, her hands gripping the table. Yes, Your Honor, but that is different. I installed mine before serving as HOA president. And did you seek HOA approval for your installation? Patricia hesitated. The board at that time determined that driveways were not covered under the covenant provisions regarding sidewalks. So the board can grant exceptions for driveways, but not for sidewalks, even though both are concrete pathways on residential property and both fall under the same covenant section. The circumstances were different. The only circumstance that appears different, Judge Flores said, her voice sharp, is that you approved your own modification while denying someone else's identical modification. That is precisely the kind of arbitrary and discriminatory enforcement that the law does not allow. She shuffled papers on her bench, then looked up at both attorneys. I have heard enough. Here is my ruling. The HOA's interpretation of Section 7.3 to ban underground heating systems is unreasonable, especially given that the HOA president herself has an identical system that has never been challenged. The covenant language does not clearly encompass underground installations that produce no visible aesthetic change. The HOA's enforcement against Mr. Lancaster, while allowing Mrs. Whitmore's identical system, constitutes selective and discriminatory enforcement. She paused, making sure everyone was listening. Therefore, I order the following. First, all fines against Mr. Lancaster are hereby vacated and eliminated. Second, the lien on his property is removed immediately. Third, Mr. Lancaster may keep his heated sidewalk system in place without penalty. Fourth, the HOA is ordered to pay Mr. Lancaster's reasonable attorney fees, which I will determine after reviewing a fee petition. Fifth, the HOA must amend its covenant enforcement guidelines to clearly specify any restrictions on underground heating systems, and must apply those restrictions uniformly going forward. And sixth, I am strongly recommending that the HOA board review its governance practices to ensure fair and consistent enforcement of community rules. Marcus was writing furiously, barely suppressing a grin. I felt a wave of relief wash over me that was almost physical. Jennifer Paulson stood. Your Honor, may we request a stay pending appeal? You may request whatever you like, but I am denying it. This ruling is effective immediately. This case is closed. The gavel came down with a definitive crack. We walked out of the courthouse into bright spring sunshine. Neighbors who had attended the hearing congratulated me. One older woman, who I recognized as living 3 houses down, shook my hand vigorously. Thank God someone finally stood up to Patricia, she said. She has been a nightmare for years. Maybe now the board will make some changes. Marcus and I went to a nearby coffee shop to discuss next steps. The attorney fees would need to be calculated and submitted to the judge. The HOA would likely drag their feet on payment, but the court order gave us enforcement mechanisms. More importantly, I had one on principle. My heated sidewalk was legal, the fines were gone, and Patricia's credibility was destroyed. How much do you think the attorney fees will be? I asked. My actual fees, about $8,000 total, but the judge said reasonable fees, so she might reduce that somewhat. Either way, the HOA pays it, not you. You are done paying for this nonsense. I went home that afternoon feeling lighter than I had in months. I called my mother and told her the good news. She cried with relief, telling me how worried she had been about the whole situation. I assured her that everything was fine now, and she could keep visiting without fear of falling. But the story did not end there. 2 weeks after the hearing, I attended the monthly HOA board meeting. The community center was packed with homeowners, all buzzing with gossip about the lawsuit and the judge's ruling. Patricia sat at the center table looking like she had aged 10 years. The other board members appeared distinctly uncomfortable. Donald Grayson called the meeting to order. He looked at Patricia, then at the crowd, then cleared his throat. Before we begin regular business, I want to address the recent court case regarding Mr. Lancaster's property. The board has reviewed Judge Flores's ruling and her recommendations. After considerable discussion, we have decided that changes need to be made to our governance structure. Patricia's head snapped toward him. Donald, we did not agree to. Patricia, please let me finish. Donald's voice was firm in a way I had never heard before. The board has voted, 3-2 to request your resignation as HOA president, effective immediately. The court ruling revealed serious issues with selective enforcement and personal bias that we cannot ignore. For the good of the community, we need new leadership. The room exploded in conversation. Patricia stood up, her face crimson. "You cannot do this. I have served this community for 8 years. I have maintained property values and standards that we imposed selectively and unfairly," interrupted one of the other women on the board, whose nameplate reads Susan Carmichael. "Patricia, I voted with you on the Lancaster case because I trusted your judgment. But learning that you have the exact same system you tried to ban him from having, that is indefensible. You made this personal, and it cost the HOA thousands of dollars in legal fees that could have been spent on actual community improvements." Patricia gathered her papers with shaking hands. "Fine. You want my resignation. You have it. Good luck running this community without me. See how long your property values last when people start installing whatever they want." She stormed out of the community center, leaving stunned silence behind her. Donald exhaled slowly. "All right. Let us move forward. I will serve as interim president until we hold elections next month. First order of business, I propose we establish clear guidelines for heating systems, solar panels, and other underground or minimally visible improvements that enhance safety and efficiency." All in favor. The vote was unanimous. Over the following months, the HOA transformed dramatically. Donald Grayson was elected as the new president in a landslide. The board revised the covenant enforcement guidelines to focus on actual aesthetic issues rather than invisible improvements. Several neighbors installed heated sidewalks and driveways without any pushback. One family installed solar panels. Another family put in a sophisticated landscaping system with underground irrigation. The community felt different, lighter, more reasonable. I received a check from the HOA in July for $7,500, representing my attorney fees as determined by Judge Flores. Marcus had asked for $8,000, and she awarded 93%. I considered it a complete victory. My mother visited every Sunday afternoon throughout the summer and fall. When winter returned in November, she navigated my heated sidewalk with confidence, never once worrying about falling. She brought me homemade cookies and told me how proud she was that I had stood up for what was right. "Your father would have been proud too," she said one Sunday in December, watching snow fall gently outside while my sidewalk remained clear. "He always said that rules should make sense and that authority should be questioned when it becomes tyrannical. You did that. You made a difference." I thought about Patricia Whitmore sometimes, wondering if she had learned anything from the experience. I heard through neighborhood gossip that she had moved to a different community in Eden Prairie, where she promptly joined their HOA board. Some people never change. But my community had changed, and that was what mattered. The following winter was even harsher than the previous one, with multiple ice storms and record snowfall. My heated sidewalk worked perfectly, activating automatically whenever conditions warranted. Delivery drivers told me my house was their favorite stop because they did not have to risk their lives getting to my door. The mail carrier thanked me personally for maintaining a safe walkway, and I never received another violation letter from the HOA. In March of the second year after my court victory, Donald Grayson approached me at a community event. We had become friendly over the months, bonding over our shared frustration with the previous board administration. "Quinton, I wanted to thank you again for fighting that case," he said, holding a paper plate with potato salad and a hamburger. "I know it cost you time and stress and money, even though you got reimbursed, but it changed this community for the better." We have had more homeowners voluntarily participate in HOA meetings this year than in the previous 5 years combined. People feel like they have a voice now. I just wanted to keep my sidewalk, I said, smiling, but I am glad it worked out. It was more than that. You stood up to someone who had been abusing their authority for years. Most people just accepted it because fighting seemed too hard. You showed everyone that it was possible to win against an unreasonable HOA. That matters. He was right, though I had not thought about it in those terms. I had been focused on my specific situation, my heated sidewalk, my mother's safety. But the ripple effects had extended far beyond my property line. That summer, I was approached by a homeowner in a neighboring community who was dealing with a similar issue. Their HOA was trying to force them to remove solar panels that the HOA president personally disliked, despite the panels being legal and properly permitted. They had heard about my case and wanted advice. I connected them with Marcus Webb. They won their case even faster than I had won mine, with the judge citing the precedent from my hearing. The attorney fees in that case were even higher because the HOA fought harder, but the homeowner prevailed completely. Word spread. Marcus started getting calls from homeowners across Minnesota, dealing with unreasonable HOA enforcement. He built a practice almost entirely around HOA disputes, winning case after case by demonstrating selective enforcement, bad faith interpretations, and abuse of authority. He told me I had launched his specialty career, and he was grateful. I occasionally wondered what would have happened if I had simply removed the heated sidewalk when Patricia first demanded it. I would have saved myself months of stress and legal battles. But my mother might have fallen and broken her hip, and Patricia would have continued her reign of arbitrary enforcement, making life miserable for countless other homeowners who committed the terrible sin of making their homes safer or more efficient without her personal approval. Sometimes standing up for what is right is expensive and difficult, but the cost of not standing up is often much higher. 3 years after the initial installation of my heated sidewalk, I was sitting in my living room on a cold January evening when my doorbell rang. I opened the door to find a young couple standing on my clear, dry, warm sidewalk. They introduced themselves as Rachel and Tom Henderson, new homeowners who had just moved into a house 2 streets over. "We heard you are the guy who fought the HOA about heated sidewalks," Rachel said. "We are thinking about installing one, and we wanted to ask if you had any advice about contractors and systems." I invited them in and spent an hour discussing the installation process, the costs, the benefits, and yes, the legal battle. They listened intently, taking notes. "So the HOA is okay with these now?" Tom asked. "Completely. The guidelines were revised after my case. As long as you use a licensed contractor and follow building codes, there is no issue. Donald Grayson actually encourages safety improvements like this now." "That is amazing," Rachel said. "In our old neighborhood, the HOA president tried to fine us for putting up a bird feeder, said it attracted pests and violated aesthetic standards. We ended up moving rather than deal with that nonsense. I almost gave up too," I admitted, "but I am glad I fought it." They thanked me and left, walking carefully down my heated sidewalk to their car parked on the slushy street. I watched them go, thinking about how one unreasonable person in a position of minor authority can make so many lives miserable, and how satisfying it is when that person finally faces consequences. The Henderson family installed their heated sidewalk in February. 2 other neighbors followed suit in March. By the following November, 8 houses in Maple Grove Estates had heating systems. The community was safer because of it. Fewer falls, fewer injuries, fewer lawsuits against homeowners from people who slipped on icy walkways. Patricia Whitmore's attempt to enforce arbitrary rules had backfired spectacularly, creating the exact opposite result from what she wanted. Instead of stopping one heated sidewalk, she had triggered an installation boom that made them commonplace in the community. I saw her one more time, about 4 years after the court case. I was having dinner at a restaurant in downtown Maple Grove when she walked in with a man I assumed was her husband. We made eye contact across the restaurant. For a moment, I thought she might come over and say something. Her expression was complicated, somewhere between anger and embarrassment and resignation. Then she looked away and walked to her table without acknowledging me. I went back to my dinner, feeling neither triumph nor sympathy. She had made her choices. I had made mine. The consequences had played out exactly as they should have. My mother lived independently until she was 84 years old, visiting me every Sunday right up until she moved into assisted living. The heated sidewalk kept her safe through 6 more Minnesota winters. She never fell once on my property, though she had close calls elsewhere that reinforced why I had fought so hard to keep the system. When she finally sold her own house and moved into the assisted living facility, one of her conditions was that the facility had to have heated walkways. She told the director about my court case, about Patricia Whitmore's unreasonableness, and about the importance of safety over aesthetic uniformity. The facility already had heated walks, but the director told me later that my mother's passion about the issue had prompted them to expand the system to cover more of the campus. Even in her 80s, my mother was still making the world a little bit safer, one heated walkway at a time. Donald Grayson served as HOA president for 6 years, eventually stepping down when his job relocated him to Wisconsin. By the time he left, Maple Grove Estates had become known in the area as a model community with reasonable rules, fair enforcement, and active homeowner participation in governance. Property values increased steadily, not because of rigid aesthetic control, but because people wanted to live in a community that treated residents like adults rather than children who needed constant supervision. The new president, a retired teacher named Maria Gonzalez, continued Donald's approach. The HOA focused on actual maintenance issues, community events, and improvements that everyone could enjoy. Violations were addressed with conversation and cooperation rather than immediate fines and threats. The community thrived. I stayed in my house in Maple Grove Estates for many years. Every winter, when the temperatures dropped and the snow began to fall, my heated sidewalk activated automatically. I never took it for granted. Every clear, dry step reminded me of the battle I had fought and won, not just for myself but for everyone who came after me. The case became something of a legend in Minnesota HOA law. Law students studied it as an example of selective enforcement and bad faith governance. Attorneys cited it in disputes across the state. Homeowners referenced it when pushing back against unreasonable board decisions. Judge Flores's ruling became a shield for countless people trying to make reasonable improvements to their homes without being harassed by petty tyrants drunk on minor authority. And every year on the anniversary of the court victory, Marcus Webb sent me a bottle of good whiskey with a note that said, "Thanks for the career." We would meet for drinks and trade stories about the latest HOA absurdity he was fighting. Some people never learned. But the legal precedents kept stacking up, making it harder and harder for HOAs to act with the kind of impunity Patricia Whitmore had once enjoyed. I retired at 65 and spent my winters in Arizona, escaping the Minnesota cold. But I kept my house in Maple Grove Estates, renting it out to a nice family who appreciated the heated sidewalk and took good care of the property. I visited every summer, checking on things and attending the occasional HOA meeting. On one of those visits, about 15 years after the original case, I walked through the neighborhood on a warm July evening. I counted 17 houses with visible evidence of heated walkway systems, the telltale pattern in the concrete, or the small control boxes mounted near garage doors. The Henderson family, those first neighbors to follow my lead, had since moved away, but their system remained, benefiting the new owners. I walked past the house where Patricia Whitmore had lived. A young family occupied it now, with 2 small children playing in the front yard. The parents waved to me as I passed. They had no idea about the drama that had once swirled around their property, the heated driveway that still functioned beneath their concrete, or the woman who had tried to enforce rules she herself violated. History moves on. Old battles fade. New people arrive with no knowledge of past struggles, but the changes remain. The precedents endure. The safer sidewalks continue to protect people every winter, and that makes it all worthwhile. I thought about writing down the whole story, creating a detailed record for future homeowners who might face similar situations. But then, I realized that the court records existed. The media coverage was archived, and Marcus Webb had probably told the story to hundreds of clients over the years. The information was out there for anyone who needed it. My role had simply been to stand my ground when it would have been easier to cave, to insist on fairness when dealing with arbitrary authority, to document everything and follow through even when the process seemed overwhelming. Those principles applied to countless situations far beyond HOA disputes. Stand up for what is right. Document everything. Find good allies and expert help. Do not back down just because fighting seems hard. The principle matters more than the immediate convenience. Patricia Whitmore taught me those lessons, though certainly not in the way she intended. Her unreasonable enforcement and hypocritical standards created the perfect test case for pushing back against HOA overreach. If she had been slightly more reasonable, or slightly less obviously biased, the case might have gone differently. But her complete lack of self-awareness and her determination to punish me for doing exactly what she had done herself gave me every tool I needed to win. I sometimes wondered if she ever reflected on the situation, if she ever had a moment of self-awareness about how badly she had handled everything. Probably not. People like Patricia Whitmore rarely engage in that kind of introspection. They move on to the next target, the next perceived violation, the next opportunity to exercise petty authority, never quite understanding why everyone around them seems to find them so frustrating. But I could not spend energy worrying about Patricia Whitmore's personal growth or lack thereof. She was not my responsibility. Making my own choices and living with their consequences, that was my responsibility, and I had made the right choice. The heated sidewalk had been worth every penny, every hour of stress, every moment of doubt. My mother passed away at 89, peacefully in her sleep at the assisted living facility. At her memorial service, I told the story about her near fall on my icy sidewalk, the catalyst for everything that followed. Friends and family laughed and cried as I described the legal battle, Patricia's hypocrisy, and the ultimate victory that had made so many sidewalks safer across Minnesota. Mom would have loved knowing that her stumble prevented hundreds of other people from falling, I said in my eulogy. She was always thinking about others, always wanting to make the world a little bit better. Even her near injury became something positive in the end. That is the kind of person she was. After the service, several people approached me with their own HOA horror stories. Unreasonable fines for minor infractions, arbitrary enforcement of vague rules, board members who treated their positions like medieval fiefdoms. The stories were depressingly familiar. I shared Marcus Webb's contact information with 3 different people that day. I do not know if any of them followed up, but I hope they did. Fighting back works. Precedent matters. Every victory makes the next fight a little bit easier. I am 72 now, still healthy, still spending winters in Arizona and summers in Minnesota. The heated sidewalk at my Maple Grove house still works perfectly, now almost 20 years old, still keeping people safe every winter. The family who rents from me sends me photographs sometimes, showing their kids playing in the driveway while the sidewalk stays miraculously clear, despite heavy snow all around. Donald Grayson and I stay in touch through occasional emails. He is enjoying retirement in Wisconsin, volunteering with local community organizations, and staying far away from any HOA involvement. He told me once that his time serving on the Maple Grove Estates Board, especially the fallout from my case, had taught him valuable lessons about leadership and the corrupting nature of unchecked authority. Patricia was not evil, he wrote in one email. She was just convinced that she knew best and that everyone else needed to follow her vision. She could not separate her personal preferences from objective standards, and when she got pushback, she doubled down instead of reflecting on whether she might be wrong. It is a cautionary tale for anyone in a leadership position. Marcus Webb retired a few years ago, having built a highly successful practice defending homeowners against unreasonable HOAs. He told me that in 30 years of practice, my case remained one of his favorites because the facts were so clear-cut and the opponent so obviously in the wrong. Most cases involved more ambiguity. But Patricia's heated driveway, her falls on ice, her use of my heated sidewalk, all of that had made the case almost too easy. "You gave me a gift," Marcus said at his retirement party. "A perfect case with a perfect set of facts and a perfectly unreasonable opponent." Every attorney dreams of a case like that. It was fun, and we did the right thing. That combination does not happen often enough in law. I raised my glass to him, grateful for his expertise and his willingness to take on a case that other attorneys might have dismissed as too small or too difficult. The $8,000 I paid in legal fees had been worth every penny, even though the HOA eventually reimbursed most of it. The principle had been more important than the money. Looking back on the whole experience now, with the perspective of 2 decades, I realized that the heated sidewalk was never really about the heated sidewalk. It was about whether someone with a tiny bit of authority could arbitrarily make rules that did not make sense, and then enforce them selectively based on personal preference. It was about whether homeowners had any recourse against unreasonable governance. It was about fairness and consistency and the rule of law, even in the mundane context of a neighborhood HOA. Those principles matter everywhere, in every context. The stakes in my case were relatively low compared to more serious legal battles. Nobody's life depended on my heated sidewalk, though injury prevention is not nothing. But the principle of standing up to arbitrary authority and demanding fair treatment applies just as much to small disputes as to large ones. Maybe more, because small disputes are easier to walk away from, easier to dismiss as not worth the fight. But every time someone walks away from an unfair fight because it seems too small to matter, the petty tyrants win. They learn that they can keep doing what they are doing because most people will not push back. They grow bolder, more unreasonable, more convinced of their own righteousness. Someone has to say no. Someone has to stand their ground. Someone has to fight the fight that seems small and stupid and not worth the trouble, because it is never really about the sidewalk. It is always about the principle underneath. I was that someone in Maple Grove Estates in the winter of 2006. And I am glad I did it, even though it was frustrating and expensive and took months of my life. Because now there are dozens of heated sidewalks in that community, keeping people safe every winter. Because now there is legal precedent protecting homeowners across Minnesota from similar arbitrary enforcement. Because now Patricia Whitmore is no longer in a position to harass people over invisible improvements that enhance safety and efficiency. The world is slightly better because I refuse to let someone else's unreasonableness dictate my choices. That has to count for something. My heated sidewalk keeps running, winter after winter, doing exactly what I built it to do, keeping people safe, preventing injuries, making life a little bit easier during Minnesota's harsh cold season. It is a simple thing, underground heating coils and a temperature sensor, nothing fancy or complicated, but it represents something larger. It represents the right to make reasonable choices about your own property, the right to push back against arbitrary rules, the right to demand fairness from people in authority, the right to fight for what matters even when the fight seems small. Those rights are not automatic. They have to be defended, case by case, person by person, heated sidewalk by heated sidewalk. That is how progress happens, not through grand gestures but through thousands of small battles fought by ordinary people who simply refuse to accept unreasonable treatment. I was one of those ordinary people. And so can anyone else be when they find themselves facing their own version of Patricia Whitmore and their own version of an unreasonable rule that makes no sense. Stand your ground. Document everything. Find good help. Do not back down. And install the damn heated sidewalk. You will be glad you did.